Greetings, everybody. Thank you for joining me in another episode on the 0% channel. Today is Sunday, December 31st, 2023, so they say, according to the Gregorian calendar. And you all know how I feel about the Gregorian calendar, including the Julian calendar. Discussed some of that information in our junior course, but there are two videos from that course that deals with Gregory and his changing of the time and the dating system. That is on the YouTube channel as well. What I want to talk to you all today about as we go into this new year, the importance of obtaining a foreign trustee. It is very important if we're going into the world of express trust, understanding the situs of the trust, that means the location of it and how it pertains to you here within the United States. We have received numerous interest from people who are outside of the United States. They're not even a national of any of these 50 countries that are here in this continent. They're not even a legal permanent resident. However, the information is getting out to them across the world, and they have interest as to how express trust can be beneficial to them. Can they do it? Does it apply in their country? The answer is you first need to understand if your country allows common law or if it only allows civil law, which is instituted by the Roman Catholic Church. Roman civil law, in other words, the lex fori. So if it is under common law, then yes, you will be able to utilize the same tactics that we use here in the United States of America. If it is under civil law, it's going to be a little bit different. Now, you can still create the trust and protect assets, but it's going to be according to how your country sets things up, because you want to make sure that if anything was to happen, you have to go to court. They're not going to excuse you out of the court for what's called a sham trust. That's what they call it here in the USA. They call it something different. Maybe they do, but it means the same thing. Sham trust means that it was created incorrectly and it is looked upon as trying to defraud your local government. And that's not what we want to do. We want to stay according to their rules and regulations, but also use it against them because we have been abused so many times. So without further ado, let me get into a document that I put together for you all. I'll share my screen and you'll see exactly this here. So what I want to talk to you about is the importance of a foreign trustee. Okay. If you are someone that has a legal permanent resident card and you were working on becoming a full-on U.S. citizenship, obtaining that, please continue. It doesn't matter. You can still do this process for yourself. If you are thinking of stopping that process, you can do that as well. I would say it's much easier to just get the U.S. citizenship and do the process under a certificate of naturalized person. Okay, there's all sorts of information inside of the website 0%.net to find out how to do that. Plus, you have all of your peers within to coach you and help you, including myself and my team members. Now, what I want to talk about is we've talked about these rules in the past, right? This is CFR 26 CFR 301-7701-7. The difference between a trust that is domestic and foreign. A trust is a United States person if, and that's the key word, if a court within the United States is able to exercise primary supervision over the administration of the trust, and that is the court test. The control test, however, is when one or more United States persons have the authority to control all substantial decisions of the trust. So those are the two parameters that any United States tax court is going to use as the basis to find out if they have the right or ability to step in and usurp the powers of your trustee and to actually direct them on what to do. That's what they're looking to do. Whenever they see a trust, they're looking at these two parameters first. So if we can knock this out of the park first, then we've just made our goals much easier. Now, a trust is a United States person for the purposes of the IRS code on any day that the trust meets both the court test and the control test. For the purpose of the regulations in this chapter, the term domestic trust means a trust that is a United States person. The term foreign trust means any trust other than a domestic trust. So if you do not pass the court test and the control test, you are a foreign trust. And that could be any type of trust. I-Show and Express Trust is the best. There are so many others out there that can pull you back into what's considered a domestic trust. So the question here is, how does the nationality of a trustee or their specific powers impact the control test? Number one, nationality of the foreign trustee. Foreign trustee, while having a foreign trustee, can sometimes contribute to passing the control test. It's not a guarantee. The IRS and courts look beyond mere nationality and examine factors such as the trustee's residence, where the trustee primarily resides and carries out their duties. And you've heard me say time in and time again, they can never have any connection to the United States. We've said this before. No legal permanent resident card, no United States driver's license or state ID. They can have a visa, a valid visa, and a passport from their country to come and go as they please. They can enter into what's called a work visa, an employee sponsorship, or they can enter into a foreign investment visa, where they provide substantial monies into a United States business. That's fine and dandy. They can do that. But you never want to have a foreign trustee be the sole trustee of your Express Trust that has any of those connections I just mentioned to the United States. That will allow the IRS and the courts to determine that they have control. A trust situs is the legal location of the trust, often determined by the governing law. So this is why we use a foreign country in the setup. You've seen that on how we process our SS4 applications before we conduct ourselves within an Internal Revenue interview over the phone. And trustee powers. The specific power is granted to the trustee regardless of nationality. And inside of the junior course, you have seen the intricate details of the duties and powers of a trustee, what they can and what they cannot do. And also, if they have the right to hire additional trust to do work on their behalf, because like we said, they're outside the United States. So someone has to be considered a fiduciary, and we talk about what they can and cannot do. What is their limit? That's called plenipotentiary of power. Okay. A U.S. trustee. A U.S. trustee doesn't automatically mean a trust fails the control test. If their powers are limited and other factors point to foreign control, the trust might still be considered non-resident. Again, take that with a fine comb. I would not institute a foreign trustee, a part of my foreign trust. I'm sorry, a U.S. trustee, a part of my foreign trust as the sole trustee. But I do have U.S. trustees for additional trusts that exist directly underneath the main foreign express trusts, such as banks, such as other trust companies, to manage other investments. You will need a U.S. trustee to do that. Number two, specific powers of the trustee. Substantial decisions. This is a key element. The control test focuses on who has the authority to make substantial decisions regarding the trust, such as investment decisions, distributions to beneficiaries, amendments to the trust, removal of trustees. So these are some basic 4 categories that you want to go into detail inside of your trustee minutes that talks about their powers and substantial decisions. Okay. Now, the situs and trust location. Here is an example of a case law. We're looking at the estate of Dorothy J. O'Connor versus the commissioner. Anytime you are dealing with a dispute for an I.R.S. determination or whatever they think that you may owe, it's going to be against the commissioner at that time. So you may look up this case. It was a case in 1990 within the U.S. tax court. This case focused on the trust situs or legal location. Though the grantor and beneficiaries were U.S. citizens, the trust was controlled by a non-resident alien trustee and governed by Canadian law. The court ultimately determined the trust was non-resident for U.S. tax purposes, excluding its assets from the estate. Let me read that last part. The court ultimately determined the trust was a non-resident. So they're saying that they determined that the trust was foreign for U.S. tax purposes, excluding all of the assets in the trust from the estate of Dorothy J. O'Connor, meaning income, real estate, all of that. Why is this? This took place because her estate EIN most likely was not established, and it most likely was not reclassified under the foreign trust. Now, we don't know if she obtained a specific EIN number for this trust using the identity of her non-resident alien trustee. We don't know if this is the only trustee. However, when you look up the case, you will find important information, which I will leave to you. So in this case, the estate has been determined to remain under the United States jurisdiction because Dorothy's estate has not been classified as not a separate entity from its foreign beneficial owner. Bringing the estate EIN under the foreign EIN would change that, which is why it is very important to have your I.R.S. confirmation to dispute any I.R.S. claims. So if you don't know what this is talking about Form 8832, entity reclassification. Any entity can be reclassified under another entity, especially a trust, to reflect ownership. If this was done, then her assets from the estate would be included in the determination that the trust and its assets is a non-resident. Look at example number 2. The estate of Edna C. McKelvey versus the I.R.S., 1987. In this case, the non-resident alien trustee had limited administrative powers, but the grantee retained significant control over the trust distributions. This fact played a crucial role in the court classifying the trust as a grantor trust for U.S. tax purposes, minimizing estate tax liability. This case is a good example of poor management of the duties and powers of a foreign person, as the trustee not being detailed entirely within the trust minutes. This may be a situation where the grantor is training the trustee and does not fully trust their abilities or poor education on the fact. However, tax liability was minimized, but taxes were still paid to the U.S. tax court. So I don't know about you, but I want to pay 0, hence 0%. The estate of Dorothy Dorothy A. Caspers versus Commissioner. Conversely, this case involved a non-resident alien trustee with broad powers over investments and distributions. The court ruled the trust wasn't a grantor trust, but ultimately excluded its assets from the estate due to the trust Cayman Islands situs and application of foreign laws. Again, this is the same situation where it's a matter of entity reclassification. The importance of that document, when the IRS lets you know that your reclassification has taken place and this entity no longer needs to file taxes, that is what you're going to use to support your dispute. See, the IRS commissioner has no idea what you're filing. It is up to you to present the evidence, and therefore, in turn, it is up to them to present their evidence if they have any to counter you. But that is his own letter that he has signed off and sealed on. So you're going to be good to go. Like we tell you guys all the time, when you submit them, these are the documents that takes the longest to be approved for good reason on their part. Every 90 days or every 60 days, if you don't receive any information from them, send it again. You keep sending it. This is your holy grail of the process. After you finish your process, this is what maintains it. Okay. Here are some additional factors to consider. Citizenship of beneficiaries. While focusing on the non-resident alien trustee, the court also considers the residency of beneficiaries. In some cases, U.S. resident beneficiaries can impact the trust classification and subsequently its estate tax treatment. So a good point to note, our express trust clearly expresses that the trust itself, being a natural person, can hold the seat of the beneficiary, ergo avoiding the residency rules of a moving corporation, such as an artificial person that can be taxed. Another term for artificial person, which is a moving corporation, individual. And how many times on applications given from the federal government are we writing our names down as the individual? And that's how they trap you into the moving corporation and artificial person classification. So you'll find information out there that talks about only an artificial person or an individual or an LLC, a corporation, can be the beneficiaries and not the trust itself. You'll find information on that. However, it is not true. And it's sad to say that the IRS puts out conflicting information. Continue to do your research is what I employ. So if you're looking for a foreign trustee, you don't know anyone in your circle of life, and you would like to have them a part of your trust that you're setting up to put everything into the trust, of course, you're not giving them 100% control. There's a way that you can control your life through paper. And the course teaches you that. Now, if you're looking to set that up, come onto the website, 0%.net. Once you become a member, you come down to the side over here, member applications, you're gonna hit foreign trustee application here. Click on the first part there. Go ahead and read all the information that pertains to why you will need to do this and how it affects your trust. Go back and hit the member order sheet, and this will allow you to download the PDF member order sheet. Okay, so you want to grab the foreign trustee order sheet and submit the completed documentation over to tzpnoimposition@gmail.com. Please type legibly. We have received some that we couldn't read, so we have to return it back, and that causes more time or delay. So please type legibly, black ink or blue ink. Upon receipt, once we receive it, it'll take us about 7 to 10 days We will have to see your proof of payment in the email as well. And from there, you are going to receive DocuSign forms. All right, there's going to be a total of 3 forms that you receive to fill out in DocuSign so that the processing can begin. Okay. So with that being said, just wanted to kind of give you a refresher as to how the foreign trustee process works. Those that are coming in who are new, this information is for you. So I hope to see you all going into 2024, allegedly, quotation marks, which is always fun. And I have a lot of new content that we're going to be expressing as we go further into the senior course, actually. So I can't wait to share that with you all. Hope you guys are all doing good, and I'll see you next time.